5 seconds to go. Start. Learned Senior Counsel submitted that the issue with regard to maintainability of the review petition after dismissal of the SLP is no more res integra and is covered by a 3-judge bench of Honorable Supreme Court in Khode Distilleries Limited's case Supra, wherein the law laid down in Kunayamat's case Supra has been affirmed and reiterated. Learned Senior Counsel submitted that Reliance placed on behalf of the respondents on the judgment in Abai Maligai Partnership Firm's case is totally erroneous, as the said judgment has been considered in Khode Distilleries and held to be confined to the peculiar facts therein, with no discussion on the principle of law. The decision of the Supreme Court in Gangadhara Palo's case stands impliedly overruled by the decision in Khode Distilleries. Learned Senior Counsel would submit that the reliance on judgment in Kapalko Kerala Resorts Private Limited is also misplaced, as the issue therein was whether, after a detailed judgment by the Supreme Court, the High Court could take a different view on the ground that certain aspects had not been brought to the notice of the High Court. According to the Learned Senior Counsel, as per the decision of the Supreme Court in Khode Distilleries, where a special leave petition is dismissed, stating that there is no ground to interfere with the impugned order, even then it is not a reasoned order. Learned Senior Counsel submitted that the decision of the Supreme Court in Vishnu Dev Sharma's case Supra, relied upon by Learned Senior Counsel appearing on behalf of the respondents, is absolutely irrelevant to the issue under consideration before this court in the present review petition, inasmuch as for determination as to what is the scope of an order of the kind, that is, order dated 13th September 18, cannot be decided by the general distinctions in law relating to exercise of power under Article 226 and Article 136. We have considered the rival submissions, gone through the decisions cited at the bar and the material on record. In the first instance, it would be appropriate to consider the preliminary objection raised on behalf of the respondents' writ petitioners regarding maintainability of the review petition. Precisely, the maintainability of the review petition is questioned by the respondents on the ground that the SLPs preferred by the state of Rajasthan stand rejected by the Supreme Court, while expressing agreement with the reasons assigned by this court in the order under review, and thus same stands merged in order dated 13th September 18 passed by the Supreme Court. Alternatively, it is contended that since the SLPs, having been dismissed by the Supreme Court after due consideration on merits, the decision of the Supreme Court is binding on the parties, and this court, therefore, the review petitions preferred are not maintainable. The issue with regard to maintainability of the review petition before the High Court after dismissal of SLPs came up for consideration before the Supreme Court time and again over the years. In Abai Maligai Partnership Firm's case, Supra relied upon by the senior counsel appearing for the respondents, where the appellants therein filed a review petition before the High Court after the dismissal of SLP. The Supreme Court, while disapproving the practice adopted, held the manner in which the learned single judge of the High Court exercised the review jurisdiction after the special leave petitions against the self same order had been dismissed by this court after hearing learned counsel for the parties to say the list was not proper. Interference by the learned single judge at this stage is subversive of judicial discipline. The High Court was aware that the SLPs against the orders dated 7th January 1987 had already been dismissed by this court. The High Court therefore had no power or jurisdiction to review the self same order, which was the subject matter of challenge in the SLPs in this court after the challenge had failed. By passing the impugned order on 7th April 1994, judicial propriety has been sacrificed. After the dismissal of the special leave petitions by this court on contest, no review petitions could be entertained by the High Court against the same order. The very entertainment of the review petitions in the facts and circumstances of the case was an affront to the order of this court. We express our strong disapproval and hope there would be no occasion in the future when we may have to say so. The jurisdiction exercised by the High Court under these circumstances was palpably erroneous. The respondents who approached the High Court after the dismissal of their SLPs by this court abused the process of the court and indulged in vexatious litigation. We strongly deprecate the matter in which the review petitions were filed and heard in the High Court after the dismissal of the SLPs by this court. The appeals deserve dismissed. Stop.